All right, y'all. I'm trying to see. Am I live, y'all? This is my first time. I'm trying to see if this is working. So I'm checking on my phone, and it still says notifications. I don't even know if I'm live. Oh, this is wild. I should be live now. All right, let me see. Still says upcoming. That's not good. How do I know if I'm live? I don't see any chat. Oh, this is okay. So we just don't have any chat.
As Judge Glenville gears up for his recusal hearing, we reviewed his most recent court appearance to glean some insight as to how he will defend himself against charges of judicial misconduct. Glenville actually laid out his entire defense, and we are going to analyze it for you. Glenville's defense consists of at least 3 parts: adhering to Rule 2.9 of the Georgia Code of Judicial, at least 3 parts: adhering to Rule 2.9 of the Georgia Code of Judicial Conduct, conducting the ex parte meeting due to an emergency relating to a threat to Woody Copeland.
Okay, so I'm not sure if I was live right now or not, since this is my first time. Okay, Skylar Banks says, hey. Nux says, yo. Okay, so we are live, y'all. Excellent, excellent, excellent. Appreciate it. Okay, so I'm going to probably just start off from the beginning again. I think I might have been here talking to myself for a minute, but that's okay. We'll get it together. We're going to bring it back. So this is what I was saying when I guess I wasn't live when I was talking to myself. You know, there's a lot of coverage on this YSL trial, particularly since Michael Steele was thrown in jail and the whole ex parte fiasco happened. Hey, Jamie D, thank you. Skylar, thank you. I see you too. Well, I see your chat. So there's been a lot of coverage, and you know, that's kind of what got my attention. So just to tell y'all about myself a little bit, I'm with Paralegal Institute. We are a paralegal school. We teach people how to get into the legal field, but this is not meant to be a commercial. It's just telling you how I got this whole thing came into my purview. So I'm a law school grad, and I was like, you know, I want to kind of help people learn about the law and learn how to research the law, so on and so forth. So just started decide. I made a decision. I'm like, I'm going to start making YouTube videos every day. The Michael Steele situation happened. Like, just when I made this decision, every day I'm going to make some videos for content, to bring awareness, to help people start learning about the law, learning how to research, etc. Y'all can go back and check. You can see what our videos look like before and what our videos look like now. So anyway, so this Michael Steele situation happens where he calls out Glenville in court, where he's thrown in jail, so on and so forth. Okay. So what I'm trying to do here, the whole idea is we want to start bringing a different perspective to people. There's some really, really, really solid, great YouTubers out there who are providing people with some analysis and providing people with perspective. Of course, we want to do the same thing, but also want to help people understand like the cases and like, how do we find them? How do we look them up? You know, how do we interpret them, et cetera, et cetera. So one thing that I've noticed is nobody is really taking Glenville's perspective. Like Glenville. Oh, thank you, Brian Steele. Appreciate it. That's correct. Glenville is like the villain to everybody, right? Glenville is seen as corrupt. Glenville is seen as the enemy. Glenville is like the person standing between YSL and true justice. And my goal as I'm looking at this is to try to be as neutral as possible. You know, with our thumbnails and so on and so forth, we kind of have to be a little bit provocative, but we're looking to be more neutral than a lot of people. So you're not going to hear me say that Glenville is corrupt, y'all. You're just not going to hear me say it. At least not at this point. You're not going to hear me bash one side or the other. What I'm trying to do is understand each side. What I'm trying to do is get a perspective on what this side is doing and why versus what that side is doing and why. And so you can really look at this as there being at least 3 sides. Okay, all right, easy. I see it's because of how he acts. I get it. I'm saying that's a personal opinion, and I'm trying to come at this from more of a neutral perspective, because that's something that you're not going to find a lot on YouTube. That's my point. And from the legal perspective, if you think about it, lawyers are not supposed to be neutral, but the judge is supposed to be neutral. So I'm trying to really play more like the judge on YouTube. I'm not judging people, but my perspective is more neutral. So what we did here is we have this video that we made where we are analyzing Glenville's. Yes, Brian Steele. I know I said Michael Steele. Sorry, y'all. I'm literally just coming off the top of the head. This is the first time I'm doing this, so mistakes will be made. But I thank y'all for correcting me. So what we're doing here is we're trying to look at Glenville. So if y'all have watched our video, and we will be taking a look at this today, if y'all have watched our video where we used AI voices to do the whole ex parte transcript in AI voices, we're going to be taking a look at that. That is what Glenville is referring to right here, right? So first, what I want to do is take a look at Glenville's perspective. Why does he feel he did? You know what? And this is kind of important in a legal sense. When you start reading like Supreme Court decisions, like for example, when you read the decision against Judge Peterson, Christina Peterson, who was just removed after she had that video where she was drunk. She wasn't, she supposedly assaulted the police officer. She wasn't removed for that reason, but the video came out and she was kind of unceremoniously removed like within a few days. You'll notice that the decision says that the body that had previously ruled on her removal, that they were not incorrect. They were not incorrect. So the Georgia Supreme Court didn't necessarily say they were right. They were just saying they did not err. They didn't go wrong. So I think what Glenville is saying here is not so much, hey, y'all, I did the right thing. I think Glenville is trying to make the case of, I did not do the wrong thing, or I didn't do something that will be considered wrong. So as we watch this, you're going to notice he's going to talk about, we noticed three different things. He's going to talk about these things that will allow him to do an ex parte meeting. Glenville gaslighting. We're going to watch the video, okay? Look, Glenville is saying I was allowed to do this meeting. Glenville is not saying, and y'all don't take this as me defending Glenville. I'm not defending anybody. The only person I might defend in this whole thing, honestly, at this point is Woody. Because Woody, when I saw the ex parte meeting and I saw how they talked about Woody and I saw the type of representation he wasn't getting, I'm not defending his history. I'm not defending his actions or his activities or lack thereof in the YSL days. But as of right now, particularly reading the ex parte meeting and seeing what just kind of the disregard for him as a human, you're going to hear me probably defend Woody from that perspective. Otherwise, I'm just trying to understand people's motives, understand people's points of view, understand people's perspectives, and then explain to y'all how I see it, okay? Unknown. He treated the state like his favorite children in defense. Okay. And you know what? I can see how you would say that. Unknown. I can certainly see how you can say Glenville seems to be favoring the state. I can see it. Particularly when he throws a defense lawyer in jail. Okay? But we're going to get to that. First, just bear with me, y'all. If you haven't seen this video yet, we're going to look at Glenville explaining his actions. Okay? Then we're going to go back and we're going to look at the transcript, which we, with a lot of work, put into our AI voices. If y'all haven't seen that yet, check it out. But we'll be watching it today. And then we're going to try to draw some conclusions about this in particular. My take on it, though, as of now, is Glenville's perspective is not I did the right thing. His perspective is I didn't do anything wrong. And that's two different things. I did what's right. I did not do something wrong. Okay? So I'm going to play this real quick, y'all. Bear with me.
As Judge Glenville gears up for his recusal hearing, we reviewed his most recent court appearance
That's not my voice,
to glean
by the
some
way.
insight
AI
as to
voice.
how he will defend himself against charges of judicial misconduct. Glenville actually laid out his entire defense, and we are going to analyze it for you. Glenville's defense consists of at least 3 parts: adhering to Rule 2.9 of the Georgia Code of Judicial Conduct, conducting the ex parte meeting due to an emergency relating to a threat to Woody Copeland's life, and asserting that what happened at the meeting will not have an effect on the trial. Stay with us as we explore each of these prongs of Glenville's defense in more detail.
So, L. Fallon, you said a judge should never have to explain themselves. This is a public trial. Glenville is laying out his defense that he's going to give, that at least the way I see it is he's laying out his defense that he's going to give in front of the neutral judge who's going to have to conduct his recusal hearing.
1. Glenville claims that the meeting was not prohibited because it did not deal with any substantive matter and did not give one side a substantive or tactical advantage.
Okay, so what does that mean? Glenville is going to make the case that, look, I didn't do anything wrong because what I did do did not benefit one side over the other. Okay? Again, I didn't do anything. He's not saying I did what was right. That's not the point. He's saying, hey, what I did didn't help this side. Now, y'all might disagree with this, okay? I'm not defending and saying I agree with Glenville's take on it. I'm just explaining his take, okay? So his take is this. This ex parte meeting did not help the prosecution, and it didn't hurt the defense. Therefore, no harm, no foul. That's what he's saying here.
This would be in accordance with Georgia Code for Judicial Conduct, Rule 2.9.
As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part.
Jamie, I'm not saying this did not damage the defense. I'm saying that Glenville is claiming it didn't damage the defense. I don't know when you say if you're referring to me or if you're kind of referring to him. I'm simply explaining his perspective, okay? So I don't want people to get upset with me. You know, I'm telling you what Glenville is saying. I actually think that there are certain things in the transcript which seem like it could be helping the prosecution or hurting the defense. And you could even argue that the entire reason for taking a prosecution witness who is refusing to testify and then helping the prosecution convince that person to testify, that obviously helps the prosecution. I mean, that's the whole point. But that's me. That's my perspective. So what I'm trying to do here, though, is I'm trying to help us understand Glenville's argument. This is the argument he's going to use, I believe, because he said this publicly now, right? He's on TV with this. Glenville is going to use this argument when he goes to the hearing. Okay.
Where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any or procedural, substantive, or tactical advantage as a result of the ex parte communication.
Okay, so y'all, I'm not gonna make y'all sit through this whole thing. So that's the key point. Rule 2.9 says, look, if you don't benefit them and you don't hurt them more or less, you know, you at least you're safe from that perspective. So that's his first point. His first point is I didn't hurt YSL. I did not help the prosecution. So if we jump briefly, if I can find this, if we jump briefly to I'm going to jump briefly to the last of the three, okay? Because these two really go together. He didn't help the prosecution is his contention. He did not hurt the defense is his contention. Why? How can he say that, right? Because we saw the transcript and we know that the whole reason that he's even doing this is to help the prosecution convince Woody to testify, right? Like, that's the whole point. That's the whole point. So how can he say that one side's not helped and one side's not hurt? Thank you, Rashad. Appreciate that. I hope y'all feel like this is good content, y'all. We're trying. So, but this is how he can say that, okay? Now, am I saying I agree with him? No. But I'm explaining, really, he's explaining himself. We're just packaging his explanation in an easy to understand format for the people. Okay, so what we just did is just repackage this long rambling kind of blah, 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 with a bunch of case citations and stuff, which we're going to get into one case, which is in the middle, which is the point number 2. He has all these case citations and whatnot. I actually looked these cases up to see what they say, right? But point number 1, Rule 2.9 lets me have this ex parte meeting as long as I don't help one side and I don't hurt another side, okay? That's going to go with point number 3, no effect. So let's listen.
States that the defendant's presence would not have affected the outcome of the ex parte meeting. Glenville cited Bruner versus State, which relates to the defendant's right to be present at all critical stages of the trial proceedings.
Okay, y'all, this is Bruner versus State. The defense has a right to be present at all critical stages of the trial. Now, these are legal terms, y'all. Critical stage of the trial. So what Steele is going to, now I don't want to say anybody's first name before I get corrected. I'm just going to say last names, y'all. What Steele is arguing is, hey, this ex parte meeting was a critical stage of the trial. We have a witness who wanted to plead the 5th, and we have a prosecution who wants to compel the witness to testify. This is a critical stage. We should have been there. Okay? That's what Steele wants to argue. Now, what Glenville is going to argue is, he's subtly going to say that this was not a critical stage of the trial based on Bruner. Bruner is a case in which the judges dealt with this sort of situation. And Glenville's going to say it's not a critical stage. How do we know that? Because it had no effect. Because, and as you're going to see, the defense's presence would have been useless. You're going to hear him say useless. Now, he's very defeated, y'all. Personal interpretation. To me, Glenville's demeanor, okay? So I'm not going to say he's defeated. So I take that back. Glenville's demeanor looks defeated in this video, okay? So he's kind of, he's down, he's not teach you to do this in the military. He's not doing that. He's kind of down here with it, okay? So is this body language showing he doesn't even believe himself? Is he tired? Is he just fed up? We don't know. So he's kind of mumbling it. But if you think about it, saying to somebody that excuse the squeaky chair, y'all. Saying to somebody that in your own trial, your presence in this meeting would have been useless. Like, we want to put you in jail, in prison. Hey, we want to put you in prison. How long? As long as we possibly can. All right, well, I don't want that to happen. Yeah, and we're going to have a meeting with this witness. I'd like to be there. Nah, your presence would be useless. Like, hold up. You trying to put me in prison, right? Like, am I the person that you trying to put in prison? You can't tell me, like, you trying to get this guy to testify against me, right? Like, you want him to testify against me. Yes, we do. And he's saying he's not going to do that. Yes, he is. And you're going to pull him aside and try to get him to testify against me. Correct. All right, well, I want to be there. Like, I have a constitutional right to be there. Nah, your presence would be useless here. Like, okay, so anyway, listen up. Again, Glenville is going to say it in a kind of downtrodden way, but listen to how he puts it.
Glenville concludes that his court did not violate this right because no party gained a tactical advantage during the meeting, and the proceedings were released as a transcript. Glenville seems to indicate that the defendant's presence at the meeting would have been useless because the meeting was about questions of law and legal arguments.
The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings.
Okay, so here we have critical stages. So, still, this meeting was critical, was a critical stage. Glenville, CYAing, y'all know what that means. CYing his A, okay? C'ing and Y'ing his A. No, he's saying it was not a critical stage.
Body within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure.
Okay, so would the defendant's presence have contributed to the outcome, the fairness of the outcome?
Versus the state, 274 Georgia, 110, pinpoint 111.
Listen up.
Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit.
Useless. So Glenville is claiming, and this is what I want y'all to analyze for yourself. Would thugs, would steals, would all the defendants' interests being represented there at the ex parte meeting with Woody, would that have been useless? So Glenville is going to argue that, and remember, Glenville in a sense is going to be, he's on trial at this point, right? Not for jail, not for prison, for recusal. But I mean, it's a hearing. It's a mini trial. I'm calling it a trial, y'all. Glenville's going to have to argue, but judge. So now he's the judge. He's going to be arguing to the judge. Judge, if they had been there, it wouldn't have made a difference. Why? He's about to say why. Why would it have not made a difference? L. Fallon, without attending, how can he deem uselessness? He's about to tell you the reason. Okay, just listen up. I'm gonna point it out.
By shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge. Okay,
L. Fallon, that's your answer. Again, Glenville is not speaking very he's not enunciating, and he's not military man with it. He's not speaking with his chest, right? Like he's down, okay? But if you notice, what did he say? He said that this meeting, he insinuated, okay, by citing this, he's insinuating that the meeting was about questions of law and legal definitions. What does that mean, y'all? What Glenville is saying, without using the words, is all we were doing was explaining immunity to Woody. That's what he's saying. I'm going to say it again. Glenville's contention, Glenville's assertion. Now, I shouldn't say it's assertion because he didn't actually come out and say it. Glenville's insinuation is this, based on the first and the third of the 3 points we pointed out. Now we're going to go to the third in a moment. On the first point, Rule 2.9 allows me to have these meetings as long as I don't help one side or hurt the other side. Okay, bam, done. 3, Bruner allows me to have this meeting as long as we're not at a critical stage, and we weren't. Well, Glenville, how do you know we weren't? Because all we were doing was defining immunity and telling Woody about immunity. So that is what he's saying, y'all. He's saying that this was just legal definitions. Okay? This was just explaining to Woody what immunity is and the consequences thereof. Okay? So let's see. Earth Angel. Any witness valuable enough for immunity must be a critical phase. Look, again, I'm explaining what Glenville is saying. So y'all, of course, I'm gonna have to keep saying this because I don't want people getting mad at me. Right? But at least you can. Okay. All right. Let's pause, y'all. Let's pause for a second because we have to go to the third point, which is really the second point here in the middle. But let's pause for a second. Emergency. Okay. The third point is actually going to, the second point, which is we're getting to third, is going to answer my question that I'm about to ask. My question that I was about to ask is this. It seems to me, does it seem to anybody else, that Glenville kind of came up with these explanations after the fact? It seems to me like, oh, okay, well, I'm in trouble now. Let me go back and look at the rules and see how I can explain that. For points 1 and 3, it seems to me like these, particularly 1, but the combination of 1 and 3 seem kind of like, oh man, let me see. Let me look at the rules and see. But point number 2 is going, if I were Glenville, Woody lawyer should have to explain, FMLA Johnson. If I were Glenville, I would have led with point number 2. So I really feel like he's putting on his defense. Again, I'm not a judge, y'all. Okay, I'm a law school grad. I'm not even a lawyer, FYI. But I did go to law school, and I did graduate. Okay, and I have been working in the legal field for 6 years. Okay, I've been teaching classes to people for forever. So I have a little bit of knowledge under my belt. Plus, I think I'm a persuasive person. And I think that Glenville's not being persuasive right now. I would have led with number 1. I would have led as with the first thing I said would have been the emergency. Because in the transcript, which Glenville, at this point, he was ready to release the transcript. That means he already knows what's in it. He already knows that the word kill was associated with Woody. He already knows that in the transcript, the word kill is associated with Woody. So if I'm Glenville and I'm about to lay out my case to the world as to why I had this ex parte meeting, the first thing I would have said is, as you will see in the transcript, kill Woody. That would have been the first words out of my mouth or something along those lines. I'm going to grab your attention. Nobody's seen the transcript yet, but I'm about to release it. So I can say this because we have it prepared and I'm about to give it to you. I'm telling you what to look for. So the very first thing I would have said, he led with, well, rule 2.9 is the blah, blah. Nah, man, forget that. I would have said, everybody, I just want you to know, I wouldn't say it like this, y'all, but I want you to know that I had grave concerns about Woody Copeland's security. As you will see in the transcript, there was multiple times it was discussed that there may be some threat to his life. And then I would go into this emergency thing. Then I would have circled back around to the Rule 2.9 and ended it with this whole no effect argument. But I would have started off with the emergency. Okay? It's funny that the audio version is not being released. Oh, Star, you know why? You know what? Y'all, I said I'm neutral. So let me. It's tough though. You know what I'm saying? Star. So let me not say you know why. The problem, how many people have heard our AI version of the, we got some people like, oh, I hate AI. Look, you know what? We're going to hire some voice actors. We're going to get Denzel Washington to play Glenville. I mean, come on. We're trying to present this in a way that people can understand it. And yes, if you heard the AI version that we made, the Woody voice is very, very funny. We didn't do that on purpose. It kind of sounds, he sounds like Jesse Pinkman from The Wire, y'all. But it's dramatic. You know, we went with that voice because it's dramatic. Okay. So anyway, on the AI, on the transcript, there's no audio, so you don't really get people's emotion. You kind of get Love's emotion a little bit, because Love kept saying, well, look, that's not right. I know y'all don't like Love either, but I'm simply saying you could get her emotion. Okay. You could get that she was not emotional, but you can get where she was coming from. She was like, look, that's not right. That's not how it's supposed to be. Y'all supposed to be looking out for Woody. You can almost hear her voice inflection in the transcript. But for other parts, you just don't know what the voice inflection is like. There's no audio, so you don't know if something's missing. If there was audio, then of course, if they chopped it up, it would be a lot more obvious. So also, I don't know for sure if audio is common for them to record. I mean, they said they were in his chambers. Does he have, I mean, what were they going to put an iPhone down or something? I don't know. So I'm not that suspicious about it. If you notice, when they were having the conversation about where to do it, they were like, well, this courtroom's taken and blah, blah, blah. He was like, well, let's just do it here. So maybe wherever he was, it wasn't set up for audio, you know? And maybe it's just not appropriate to just whip out your cell phone and record that kind of conversation. You know, like, you're going to be here like, hey, you know, here we are. So maybe it's just not set up for that. Okay, so we could be suspicious about that, but we don't necessarily have to conclude that that's corruption. Okay, again, they were in his chambers, I believe it was. And according to the transcript, unless we're gonna go with the conspiracy theory, you know, oh man, well they put that in the transcript so they could say that's why they know. I don't know. But going back to our topic, y'all, emergency. Why did he not lead this whole explanation with, I'm about to give you a transcript and you're gonna see that they were talking about killing Woody. Okay. Also, did y'all notice in the transcript there was no question about who's saying they're gonna kill Woody or anything? Like, there is some weird stuff. Like, if I'm a judge and somebody's reading, they're like, y'all, what's his name? Melnick. His prior lawyer, somebody put the name here, Melnick, said that you're gonna get Woody killed. I probably would have been like, is there a legitimate threat on his life? It seems like if you care about Woody, you would say, hold up, they're talking about killing. Well, who's talking about killing Woody? Like, do we believe this is actually, is this just talk? Can we get this Melnick on the phone so we can ask him some questions? Like, why did he say that? There's nothing of that. Melnick said you're going to get Woody killed. Silence. You know, the only thing is, Love wanted, hey, we're not going to kill Woody. Well, I don't think that's what the lawyer was saying. But anyway, somebody said it. Nobody seemed to care in the transcript enough to even ask any additional questions about that, which is strange, but maybe it's not strange. Okay, because Woody's, Y. Brooks says Woody's safety wasn't the main topic during the meeting. Y.S. Brooks, excuse me. Look, Y.S. Brooks, think about this though. Woody's safety wasn't the main topic of the meeting, but what do you see here on the screen right now? You see the word emergency. Woody's safety was the very reason he got to call the meeting. How are you going to have a meeting because somebody's safety is at stake and during the meeting you barely talk about it? Think about that. You can't say, hey, somebody's talking about they're going to kill Woody. We need to call this meeting now. Okay, we're going to call the meeting. But we don't need to talk about that whole killing Woody stuff. It's like, well, then we don't need this meeting now, do we? If we're not going to talk about the very thing that allows us to call the meeting, then we probably don't need the meeting. So my point is this emergency. Okay, well, listen. Let's just listen to a little bit of this.
Suggests that the ex parte meeting was conducted as an emergency after Mr. Melnick expressed concern that someone may kill Woody Copeland. Glenville cites a court case, the United States versus Adams, to support this contention.
I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick.
Okay, y'all notice there's a transition right there.
And
if I was watching this, I would say, well, what did Mr. Melnick say? You know why there's a transition there? Because that's all he said. He did not even say, when I say he, in giving his defense of himself, Judge Glenville did not even say that Melnick said somebody might want to kill Woody. He didn't even go into that. He just said the state's concerned about what Mr. Melnick said about Woody. That's it. So Glenville fumbled, in my opinion. He did not, at this point, this is the court of public opinion. He gets to do this over in front of the judge. So I'm kind of giving Glenville some pointers here in a sense on persuasion. He knows the law, but he's not being very persuasive right now. Okay, Yaya says YSL isn't in trouble. We're gonna get into that, Yaya. We're gonna get into that in a minute. Okay. So, Varian says, good morning. That's what I'm saying. Reading the transcript sounds like Glenville and the prosecutors manipulated him into believing immunity wasn't his choice. We're going to get into that in a minute. So from the persuasion standpoint, Glenville fumbled. He said part of the reason we call this meeting is because of the state's concerns about what Melnick said about Woody. He never, Glenville, in this explanation, he doesn't even say what Melnick said. What did Melnick say? Somebody might want to kill Woody. He didn't even say that. So I'm like, I'm trying to convince people, because that's why I'm reading this, that I had a reason to do what I did. Somebody's life being in jeopardy is the number one reason you can do almost anything. And I don't even explain that right. That's crazy. I shouldn't say crazy. It's unpersuasive, y'all. That's what it is. It's not crazy. It's unpersuasive. So,
and in Adams,
here he goes into a case called Adams. Let me see. Y.S. Brooks. The emergency was they didn't want him to plead the fifth again. If his safety was the issue, they would have talked about it more during the meeting. Okay, Y.S. Brooks. I am literally just showing you what Glenville said himself. Like, he's the one that literally just mentioned it.
After Mr. Melnick expressed concern that
but by the way, yes, he did mention the pleading the fifth after this.
Woody Copeland.
Okay, that's cut
Glenville
out.
cites
so
a court case.
You are correct. I would say, in my opinion, you're half correct. Glenville mentions the emergency being pleading the fifth and what Mr. Melnick said. So he does mention both things, okay? The pleading the fifth was not in this video that we made, but yes, the pleading the fifth is definitely a part of it. So then I guess what we want to ask is this question, y'all. First of all, if you are a judge and you're judging Glenville and he tells you Melnick says he thinks Woody might get killed, so I felt I needed to call this meeting. The problem is they don't really talk about that in the meeting. So I don't even know why Mr. Glenville is bringing that up, because they don't talk about that in the meeting. I mean, it's mentioned, but they don't discuss it. In fact, Y.S. Brooks, if you notice in the transcript, the prosecutor Hilton, when she's talking directly to Woody, she says, she spends most of her time, and this goes to your point, Brooks. Is it Brooks? I'm sorry, I'm saying Brooks. Books, Y.S. Books. My apologies. She spends most of her time talking about how he won't get in trouble for saying pretty much anything. They won't be able to use it against him. So she spends most of her time talking about the pleading the fifth aspect And when she talks about his personal safety, she's like, yeah, well, we could do something about that too. I told you that. But let's get back to this pleading the fifth thing. So you're right, books. Almost the whole time they're talking about pleading the fifth. But Glenville mentions what Mr. Melnick said here. So we can't. So what I'm trying to do right now, again, is explain Glenville's point of view. Explain his defense that he is going to use based on what he said here at this hearing, at this in court. Okay? So Glenville mentioned Mr. Melnick. What did Melnick say? He said you're going to get Woody killed. Okay? So Glenville is bringing that up as part of his reasoning. And if you listen to the Adams
United
case,
States versus
this particular conference in front of the court is that
I won't bore y'all with this. Y'all, if you want to learn about paralegal stuff, I mean, I don't know if you're going to become a lawyer or what, get in touch with us. You know, we're doing this. I did look up this case. I read the case. And I put the case overview here in this video. So if you want to hear this Adams case, it's somewhere around 3 minutes into the video. Bottom line, Adams had complained about an ex parte meeting the same way that YSL is complaining. Adams had been convicted on appeal, said, hey, I need an appeal because they did this ex parte thing and that's not right. And the appeal was not successful because the judge said, well, that ex parte, the witness, get black with me. Oh, get black with me. CYA mode. I used that term earlier. CYAing or seeing Ying and Aing, right? The witness in the Adams case had fears for his safety. So Glenville is saying, hey, look what happened in Adams. They did an ex parte when a witness had fears for his safety. That's what I did with Woody. That's why I say he fumbled here, y'all. Going back to YS books, he can argue that, but it's clear they definitely wasn't in an emergency. Right, so I agree with you. Well, that's why I'm saying Glenville's fumbling, y'all. Because he has to make the case. That's my point. My point is, what does Glenville need to do? What would you expect him to do right now? The very first thing you would expect him to do is say, somebody was trying to kill Woody. Shock you. Like, not like that, but obviously. Somebody wanted to kill Woody, y'all. And I had to protect him. Now, once you read the transcript, you'll see that it doesn't really work out quite like that. But it was mentioned. It was mentioned. So, y'all, listen. I also want to be very clear, y'all. Again, I said this earlier, and I want to be very clear. I feel uncomfortable, a little bit uncomfortable using this term kill Woody. So it's in the transcript, but it just feels a little uncomfortable for me to say this about another person. I don't really like, because his life may have or may be in danger, y'all. So I just want to say I'm transcript. I don't take that lightly, though. Okay, he's a human, and I really do think that he deserves, life, liberty, and the pursuit of happiness like everybody else. But I'm saying it this way because it's in the transcript. And frankly, if Glenville wanted to convince us, he should have led with that shocking information. You want to know why we did this ex parte meeting, y'all? Because we were scared for Woody's life because Mr. Melnick, his attorney, told us that somebody was trying to take him out. And then we would be like, what? We would read the transcript and then we would be debating. Some people would be like, oh, the transcript doesn't say that. Other people would say, no, it does say it. Glenville would have sowed the doubt among the people, but he fumbled. He fumbled, okay? So where do we stand now? Glenville has given us 3 reasons why he should, why he did what he did. And for putting it from my perspective, the strongest argument is the emergency. So Glenville's saying, I looked at this, I saw an emergency, I quickly scanned the landscape and I noticed that according to Rule 2.9, neither side would be benefited or hurt by this meeting, but I might be able to protect this guy. And after all, what do we really need to do here besides just protect him? We need to talk about pleading the fifth. And what is pleading the fifth? It's just some legal stuff that even if the defense had been there, it's just some legal stuff. It's just some legal definitions and stuff, some legal explanations and stuff. So even if the defense was there, their presence would have been useless. Now, again, if I'm Glenville, I probably would have, I'm not going to say that, y'all. Glenville, if he's defending himself, he should have said, we couldn't have the defense there because we were talking about Woody's safety. So not only would their presence have been useless, it might have been dangerous. He didn't say that. Maybe there's a reason he didn't say that. I'm talking about how he defends himself, Glenville, his actions, okay? So, I'm certainly not insinuating that would have been the truth, okay? I'm not insinuating that would have been the truth. But simply, he's trying to defend himself, and he fumbled. He totally fumbled. He dropped the bag. Okay, so Glenville has given this whole explanation. How many people out there? I'm trying to look at the chat. Let me see. Joe K says, "How can you know if defense being useless until after the meeting?" So I would say Glenville's reason for convening the meeting is so that the prosecution can convey to Woody the implications of not testifying. So Glenville's perspective is, I called this meeting because we needed to have a discussion about a legal topic that had the defense been there, they couldn't have said anything. Because what are we doing? We are explaining to Woody, testifying would be, what could the defense possibly say? Because we're just literally telling him what so where would they object? Where would the defense, again, I'm thinking as if from the Glenville perspective, where would the defense object? Woody, we gave you immunity. There's no objection because they did. Woody, you have to testify. If you don't, we're going to throw you in jail. You can't object to that because that's their right. I mean, that's their prerogative, right? How long are you going to keep Woody there, Miss Bumpus? How long is he going to be in jail? We can keep him there for, years, basically. Where would the defense have been able to interject and say something that would have changed the course of everything? You could maybe say, okay, maybe the defense can't say something, but they can learn some information, right? So you might say, well, no, the defense could not have changed the course of that conversation. But them being there, they would have gained valuable information. They would have known some stuff that they can now use in the defense. Some things some Brady information that they have a right to know. Okay, so like we just take it out of what would the defense say, and we put it into what would the defense learn. That's one thing. Also, I do think that it is debatable that there was only legal definitions and explanations happening here. At one point, Woody said, and I guess this does go back to who was that just said that? The person, I'm sorry, who just said, well, how do you know what's going to happen in the meeting until after? Speaking as me, not as, from the perspective of Glenville, but speaking as me, Woody says, I never told the truth about anything. Woody says, I committed those crimes. So from that perspective, you have a good point. When you start this kind of meeting, anything can happen. Anything can happen. We don't know what's going to happen. So how can we say before the meeting that the only thing that's going to happen during the meeting is like a nice, easy, smooth explanation, and that's it. Right? I think that's where Glenville would come in. And y'all, this is another key point that he mentioned here multiple times. Let's see. Let's go to Adams, y'all. I don't know if I'm gonna see it here in the Adams overview, but Glenville mentions during this explanation that a transcript was available. In these previous cases, a transcript was made available. In these previous cases, the court reporter recorded what happened and then made that transcript available to the other side. So what Glenville is arguing is, if something off the beaten path, if something unexpected, if something weird went down during this ex parte, we don't know ahead of time that something's about to go off the rails. There's no way to know, but we know what our intention is. Our intention is just to explain a legal concept, a legal implication to Mr. Copeland. We just here to tell him some legal stuff that the defense really doesn't have anything to do with, that their presence would have been useless. But just in case something did happen that's of interest to them that we couldn't have foreseen, we certainly didn't call the meeting for that reason, there's a transcript so they can read it and then they can do with that as they like. See? So Woody could not refuse the immunity. Okay. So I hope everybody's up to speed. So just as a recap, Glenville says Rule 2.9 allowed him to call the meeting so long as he did not prejudice one side or benefit the other side. Glenville also says that had the defense been there would have been no effect. This would have been from the perspective of Glenville calling the meeting, from the moment he decides to put the meeting together. He's not saying this after the fact that, hey, the meeting we just didn't have any effect. Would have, if the defense would have been there wouldn't. No, he's saying, when I'm making this meeting happen, the reason that I'm putting it together is something that involves legal explanations and that sort of thing. And so, provided it just goes as I expect it to, if the defense is there, there's nothing for them to do. But they're just useless. Their presence would be useless. So I'm not. Okay, so he's saying there will be no effect. So he's going back in time with his explanation. My state of mind at planning and putting this meeting together is that even if the defense is there, there won't be any. It will be useless for them to be there. After the fact, who knows? But before the fact. So he's looking at, I'm going to call this meeting. Does the defense need to be there? Nah, we're just going to explain Fifth Amendment to Woody. Okay? So if they're there, there's no effect. And then 3, he says emergency. Woody's about to testify. He wants to plead the Fifth. We're going to have to put him back in jail. Oh, and by the way, Mr. Melnick says somebody's trying to kill him or going to kill him, or he might get killed or whatever. However Mr. Melnick phrased it, you're going to get him killed. Okay? So this is the entirety, as far as I'm concerned, of Glenville's arguments. When we add the fact that he underscored multiple times, this was important, y'all. There's a transcript. So even if during the meeting something happened, you get to read about it later. No, you weren't there, but we didn't think you needed to be there. You can read about it. Now I want to ask y'all a question. Woody did testify after this meeting, right? I'm going to say it again. Didn't they have this meeting Monday morning? Woody was on the stand on a Friday. Robo Karsten, the state called the meeting, not the judge. Listen, I think I'm not sure that matters much. They did it with the judge's knowledge, and they did it in the judge's chambers. I mean, he's just as responsible for the meeting as anybody else, okay? As far as I'm concerned. If the state had done the meeting and the judge wasn't there, that would be different. Okay? He was there. He conducted the meeting. He's the judge. He is the senior person with seniority, not seniority. He's the authority. So that's Glenville's meeting, y'all. Okay? If Glenville hadn't been there, it'd been a different story. So Woody's on the stand on a Friday. He's pleading the fifth on a Friday. Glenville says, look, man, if you don't want to start answering, first he says, I just want to remind you, you've been given immunity. If you don't want to answer, there's going to be some problems. And Woody continues to plead the fifth, and Glenville says, okay, why don't you just spend the weekend in jail? Monday morning, Woody's out of jail, apparently. He's in the courthouse, and Glenville and the prosecutors want to have this meeting so that they can get him to talk. Didn't Glenville put Woody on the stand on Monday? Didn't Woody start to talk? This is where I'm a little unclear, because I feel that Woody did come onto the stand on Monday. He did start to talk. Wasn't that the day that Woody started saying everything that I said before I don't remember, and so on and so forth? Because if that's the case, it would seem to me that Woody did testify again before Steele and YSL had the transcript. And to me, that might be a big problem for Glenville. So somebody in the chat, let me know. Did Woody on Monday, after he spent the weekend, yeah, he got on the stand. Because you even remember in the transcript, they were trying to get some clothes for him. And Woody said, nah, man, I want to go out here like this so I could show him how y'all did me. Didn't Woody go up there Monday and testify in his jail clothes? Because if he did, I think Glenville is going to have to explain, okay, you had this ex parte meeting. Okay. You didn't think that the defense needed to be there. Okay. But why did you put Woody back on the stand before the defense had the opportunity to read the transcript? Now, Glenville will probably say, because Woody's still under direct examination, the defense can't even ask him any questions yet. And I was going to make sure that, in other words, y'all, just so that you know, if you've been watching, Woody testified after the ex parte, Wealthy Wisdom. Woody testified after the ex parte hearing. That's the same they still, yes, exactly. The same they still mentioned about the ex parte meeting. Correct. Woody had testified that day. So Woody was under direct examination. That means that he was the witness for the state, and the state was examining him. They were asking him questions. Cross-examination is when Steele goes to ask him questions. So Steele has still not gotten around to asking Woody any questions. So when we say, Glenville, okay, you felt you needed to call this meeting due to Fifth Amendment, due to Woody's safety. Y'all didn't really talk about Woody's safety, but whatever. You needed to call this meeting, fine. You didn't think that anything would happen except for you were going to talk about legal concepts and legal explanations, and that the defense's presence would have been useless. Fine. You made a transcript. Excellent. Why didn't you provide that transcript to the defense before you put Woody back on the stand? So what is Glenville going to say? Glenville's going to say, well, Woody was under direct. The defense couldn't ask him any questions yet. And therefore, they didn't even need the transcript because they can't ask him any questions yet anyway. Y'all, it is getting, as we build everything, it's getting worse and worse for Glenville. It's getting worse for Glenville, y'all. Okay? If we could stop here, he might be able to save himself. He might be able to save himself and say, if we stop here, there's nothing else to say about this matter. Another judge might say, okay, all right, I can kind of see that. Don't do that again. But one last piece to the puzzle is when was Glenville going to tell the defense about the meeting? If Glenville had told the defense immediately about the meeting, hey, I just want to let y'all know before we get started today, we had this meeting this morning. We explained to Woody his right to plead the fifth, but that we will put him in prison, blah, 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 or jail. If he had just told them, this whole thing probably wouldn't have blown up. Yeah, still would have been upset, but he would have been informed, and then you don't have this secret aspect. It was secret in that he still didn't know what was going to happen, but the way Glenville responded in court, like, who told you that? Like, it was supposed to remain a secret forever. I think that's what might do Glenville in, y'all. I don't think the meeting is going to do him in. I think another judge is going to look at this and they're going to say, you know what? Like they said in Adams, y'all. Look at this. Look at this. Y'all, look at this on Adams. Look at what a court, was this the court of an appeals court ruled? This is a U.S. appeals court. The court found that although certain portions of the conference raised the appearance of impropriety, defendants were not prejudiced and therefore no reversible error occurred. Y'all, no reversible error occurred doesn't mean that they did right. It means they didn't do wrong, as I told y'all earlier. This is legal speech. We don't know if you did the right thing, but we will say we don't see that you did the wrong thing. So, I'm going to read this again. Think about Glenville, y'all. This is a previous case from 1980 something. Okay? Glenville is saying, hey, look at this case and look what the appeals court said in this case. This applies to me. This is how the law works. Well, what is it that the case said that applies to you, Glenville? The case says that although certain portions of the conference looks bad, there was no help here, there was no harm there, and therefore I didn't do anything wrong. No reversible error occurred. So Glenville's going to say to this other judge, he's going to say, it might look bad, yeah. It might not look good. Glenville chose a case that purposefully chose a case that didn't look good. Y'all see this? Do you understand? Do you understand that Glenville is purposefully choosing a case that looks bad because he knows his case looks bad? Again, it's my interpretation. I don't know him. I've never spoken to him, right? But do y'all understand that Glenville apparently is choosing, like, let me find a case where it just looks bad, but it came out on the same side I wanted to come out on. Glenville, Clarence Kennedy, Glenville cited old law, but one of the lawyers raised a citation in the 90s and called it old. And he called it old. So when you look this up in Lexus, it's going to give you if y'all can see this little green thing over here, if you can see to the right of your screen where it says positive, that means that this law is still good. Okay? So Lexus is going to tell you if the law is still good, if it's kind of shaky in parts, meaning certain parts of it might be overruled or called into question. And then it'll give you, that's yellow, and it'll give you like a red. It'll give you a red if it's like, nah, don't use this because this is outdated. It's not based on the date though. So who was that said that again? Clarence. It's not based on the date. It's so when they say it's old, you could make any kind of argument you want, but it's not so much based on the date. It's on what's happened in that in that field, within that sphere of legal reasoning since that time. This is still good law, y'all. Okay? And by the way, you can say whatever you want to try to become convincing, but this is still good law. He found a case that you think Glenville didn't do this on purpose. He probably has a clerk. He's like, look, this is my dramatization. I don't know what he said. Obviously, I wasn't there. But let's just imagine. Clerk, I need you to find me a case with an ex parte meeting that looks really bad, but it came out on the judge's side. Can you do that for me? Okay, let me find that. Oh, here we go. Adams. Okay, let me read this. Yep, looks bad. Appearance of impropriety, but defendants were not prejudiced. Okay, perfect. Thank you. That's all I needed. That's all I needed. So now when he goes in to his hearing, he's like, Judge, can you just take a look at Adams? I mean, the judge will have already seen, I'm sure, but he's arguing. Look at Adams. Look bad. Nobody was hurt. Nobody was helped. Look bad. But no reversible error occurred. All right. So Glenville is citing Adams for a reason. I'm just gonna read this, y'all, real quick. The court affirmed defendant's convictions. Now, of course, YSL has not been convicted, but that's not the point. The court affirmed defendant's convictions because their due process rights to a fair trial were not violated. Y'all see how this legal talk is? Not violated. So in other words, nothing wrong was done. Were not violated by an ex parte conference between the district court judge, which Glenville is a superior court judge. That is the state equivalent of a district court judge. So this is federal, y'all. Okay. Glenville is on the same level in Georgia as the judge was who originally had this in federal. It's the first level. It's the trial court. Okay. So ex parte conference between the district court judge, the prosecutor, and the prosecution. This is literally the exact scenario. District court judge, superior court judge. That's Glenville. Prosecutor, that's Love and Hilton. Prosecution witness, that is Woody. So y'all, this is the exact scenario. The court found that, when I say exact, I just mean the participants. I'm not saying what happened in the meeting. Of course, that's not the same. But the participants who were there, and the fact that the defense is raising a challenge to this, is the same thing that happened. Okay, so the defense is challenging this, is the same thing that happened with is the same thing that happened with Glenville, Love Hilton, and Woody Copeland. Okay. The court found that although parts of the conference raised the appearance of impropriety, it was not prejudicial to defendants and did not affect the fairness of the trial. So y'all, at the end of the day, so if you want to know what's going to happen with Glenville, I literally just showed you his defense. Rule 2.9, the fact that there was an emergency. As someone pointed out, part of the emergency was the pleading the fifth, and they wanted to put Woody on the stand. I don't know if I would use the word emergency, but an urgent situation. Also, somebody was talking about doing something to Woody, apparently. And then also Glenville saying that had the defendants been there would have been no effect. Get black with me. Was the witness sworn in? Oh yeah. You mean on Adams? Yes. Remember, so Adams is at the appeals court. So the appeals court is reviewing what the district court judge did. So this is the outcome of an appeal. By the way, y'all, just as a point, again, I mentioned this earlier. I started doing this years ago. We didn't really get any notice until we started talking about YSL, which is good. I want to thank everybody. Thank you all for being on stream today. Thank you all for watching our videos. It feels good to feel like you're giving value to people. So I just want to thank everybody. Like, comment, share, subscribe. Send it out to all of your friends. 4th of July, put it on the big screen, whatever. But I got I got started with this channel because I wanted to kind of help people learn. So one thing I want y'all to all remember, some of you will know this, some of you won't know this. You're not going to get anything in that we're citing to as case law unless it's an appeals court or Supreme Court decision. And remember, you have the appeals court and you have the court system on the state level. You have the court system on the federal level. It is interesting that defendants appealed a judgment entered in the United District Court for the Northern District of Florida. So I want to tell y'all something. This is interesting. I don't think this is going to matter. But this is interesting. Something that y'all should note. The federal court system is separate from the state court system. Glenville did not. This Adams case. I'm not talking about all the cases he pointed to, but this Adams case in particular, the one where there was the appearance of impropriety. This isn't a Georgia case, and it's not a U.S. Supreme Court case. So really, it doesn't have any precedential weight in Georgia. Georgia appeals court rulings. Georgia in Georgia. Same thing goes for all the other states. Your Florida appeals and Supreme Court rulings are going to have precedence in Florida over the trial court. Same thing goes for Nebraska. Same thing goes for all the states. But your federal appeals court ruling is not really a precedent for your state courts. They can't bind a state court. The Supreme Court can bind all the courts, but the federal appeals court can't bind the state court to do something. So he's kind of, it does kind, I don't know if this is going to be the way that the judge, his recusal judge is going to look at it. They might just read this case and say, oh, okay, well, he found a case, but it's not a Georgia case. And it's not a Supreme Court case. So that is something of note. Okay. Uncommon sense. Uncommon_sense. Likes increase viewership. So yeah, y'all, if you would like, again, comment, subscribe, send it out to all of your friends, all your family. So let me just point out to y'all. I want to tell y'all what happens next. Okay. I want to tell everybody what's going to come up next. So the next thing that's going to happen is that this is going to go to a hearing for Glenville. Did everybody notice? This is something that I saw on another channel. I'm going to have to pull that channel up. Let me see here. 1 second. Y'all going to see my desktop for a second. Let me get this up. Also, I wanted to... All right. There's another channel. I forget the name of it. His name is, let me see if I can find it. Like Above the Law, something like that. He has like a bunch of subscribers. Really, really, really informative guy. And he said that the lead attorney, something like that. Lead attorney, something like that, y'all. Really informative guy. And he said that this case actually was assigned to another judge. I think her name is Benita, and that she recused herself. So we made a video about this. I think it was a short, and we were like speculating, what if all of the judges that this is assigned to, all of the Fulton County Superior Court judges, what if they just start recusing themselves, saying, hey, we can't judge Glenville. We can't judge. That's our boy. That's our colleague. That's our chief judge here in the Superior Court. We can't judge him. So apparently the first person who this was assigned to did recuse herself. But we're going to get to that, what you said, wealthy wisdom, in a sec. But the judge has been assigned to, her name is Krauss. Now, if you all haven't watched this video here, check out this video, Outside the Law. Krauss is the person who is hearing this. Okay? Krauss heard this, so if y'all want to know who has Glenville's case,
DA's office has
check this out. Listen to what she says here. Oh my gosh, another ad. Listen to what Krauss says here, y'all. This is the person who's going to have
In the
Glenville's
ongoing
case.
litigation between the merchant law firm,
Okay.
the latest developments saw the DA's office.
This is the
appear in
lady who
court
has
hearing
Glenville's case
and
now.
essentially argue that it does not exist.
But let's not completely dismiss the county's point that the Fulton County District Attorney's Office is not a formal entity. It's not.
The Fulton County District Attorney's Office is not a formal entity. So, Wealthy Wisdom, you said no judge in Fulton County should be allowed to hear the matter. That is what Doug Weinstein is arguing. He said he cited case law where he wants this matter, this recusal, not the YSL trial, y'all, the recusal hearing for Glenville. He wants that moved out of Fulton County to a whole nother county. Okay. Earth Angel says agree. So I think Earth Angel is agreeing that this should be moved out of Fulton County. I don't know how you are going to give a recusal hearing to somebody who works for one of the parties involved. Like, would you give the recusal hearing to Brian Steele's co-attorney? You know what I mean? Like, it wouldn't make sense, would it? Like, it seems like you would want to move this to a neutral jurisdiction so that you can get the semblance of neutrality. Plus, that it seems like you would be less likely to get an appeal. I mean, they're going to appeal either way, maybe. But your appeal would be stronger. I think your appeal request would be stronger if this had been put into a neutral jurisdiction. But let's listen to what Judge Krauss says, because this is going to give us a little bit of a sense for who Glenville is going to be going up against. Or not against, excuse me, who he's going to be going up in front of.
And essentially argue that it does not exist.
But let's not completely dismiss the county's point that the Fulton County District Attorney's Office is not a formal entity. It's not a municipal body. It's not an incorporated entity. It's just a name that we've given. I mean,
the Fulton County District Attorney's Office is just a name that they've given to something. Okay? So if y'all haven't looked at this video, this Fannie Fulton DA outside the law, why do we call it that? Because this case is the Trump stuff, and the Fulton County District Attorney's Office is saying, hey, we don't have to give up any documents because we aren't even a real thing. We don't even exist. Then how do they exist? Give back. So one of the Trump co-defendants has requested documents and sued the Fulton County District Attorney's Office for not giving them the documents. They sued the Fulton County District Attorney's Office. Fulton County replied, hey, to this judge, replied, hey, can you just go ahead and dismiss this because there is no entity called the Fulton County District Attorney's Office. So whoever they requested that from, that entity does not exist. And this judge is saying, yeah, that's true. That entity does not exist. So get black with me. How do they exist? I don't know. If you watch this video, you will see that the outcome is that the attorney who is requesting the documents, who's suing, said, look, well, first of all, the Fulton County representative, the lawyer, said maybe they can sue the Fulton County DA, Fannie. It's a lawsuit to get her to produce documents. The opposing attorney, I believe this is again an attorney for one of the Trump defendants. He said, well, the case law says that the Fulton County DA and the Fulton County District Attorney's Office is the same thing. So the judge at the end, spoiler alert, the judge said, I'm going to give you some time to just add Fannie, Fulton County DA, to the lawsuit. So they haven't even gone through all the steps yet. But I'm trying to give y'all a sense for who it is that's going to be judging Glenville at the moment. It's this lady. I don't have a problem with her. Okay, I don't think she did a bad job. I'm not criticizing her. I don't even know that I'm in a position to criticize her. But I'm showing you who's going to be judging Glenville. It's this lady.
If you were to sue,
watch the video.
A lot of
I mean, I have every reason to believe this judge is, does an excellent job. I don't know her. I have every reason to believe she does an excellent job. But I'm just giving you a sense for us having a video on her. Now, I'm going to close this out with, why did we say YSL in trouble? Okay? Why did I put that? I'm pulling up something on my other screen here. Why did I put that as the thumbnail? I mean, was that just clickbait? We just clickbaiting y'all into having this beautiful conversation with me today. No, we're not just clickbaiting y'all into that, y'all. I think that Brian Steele, see, y'all, I didn't say Michael again. I said Brian. I said it right. Brian Steele said something, and I would pull this up. Right now, but it would just take me too long to find it. Brian Steele said something that when he went on his rant, which was a very understandable rant. Don't get me wrong. When he went on his rant against Judge Glenville, he said that he had information that Woody had admitted to killing Nut. That's what he said. Man, I should have had this lined up and ready to go, because now that I said that he said that, I should be ready to play. I should probably be ready to play him saying that. But at any rate, can somebody back me up on that? Does anybody remember Mr. Steele? This was literally right before he said he had information that Woody had said he killed Nut, and also the bailiff was like right up on him at that moment. He said, "Hey, don't take my notes," and then it was over. But y'all, the reason I said YSL in trouble is because that was kind of a major assertion that Mr. Steele gave, that he had information that Woody killed Nut. Excuse me, I misspoke. He had information that Woody said that during the ex parte meeting. That's what I want to say. Not that he has information that Woody actually did something. That he had information, or that he understood that Woody had said that during the ex parte meeting. Okay, that's what I wanted to say. Okay, so Jerome H says, yeah, but I don't think that's the full transcript. Okay, so the reason why I said YSL in trouble is because also Mr. Steele's statements are part of the record. Okay. Y.S. Brooks, not a direct quote from Brian, but Woody did say, okay, yes, no, you're right. Woody did insinuate and allude to the fact. He even said, I did all those crimes, or I did all these crimes. Okay, so Woody did insinuate or allude to doing some stuff. Yes, 100%. But he certainly did not in the transcript say even emphatically or even insinuate that he killed Nut. And so when Mr. Steele said that in court, I feel like part of his outburst, of course, was the ex parte meeting, but part of it was that he felt that if Woody had said this would be somehow good for the defense. And when you read the transcript, Woody didn't say it, and he didn't insinuate it. There's nothing in that transcript that I saw that could even be contorted to be that Woody is claiming responsibility for that. Again, I'm not saying what Woody did and didn't do. I'm simply saying what the transcript states and what Mr. Steele said in court. So that's one reason why I said YSL in trouble. Another reason, y'all, is I really think Glenville's gonna stay. I think Glenville is going to be found by this judge, provided everything stays with her, is not transferred to another county, is not. I think Glenville. I'm predicting she does not remove Glenville, y'all. This is my. Before we made this video here about Glenville's defense, I was saying I thought he was gone. But she's a judge. He's a judge. They work together in some capacity. And he's saying, look, we were just explaining to Woody what's going to happen with his Fifth Amendment. And then he says, look at the transcript. That's what we were concerned about. We were just concerned with him testifying because we gave him immunity. Well, what about the fact that he said a couple of other things? Well, we were preparing this. We didn't know he was going to say that. That's not what the meeting was about. We were preparing the transcript to give it to the defense. The defense never got to cross-examination. They have the transcript before cross-examination. And if you look at Adams and these other cases, you can see that sometimes it is appropriate to have these ex parte meetings. If Glenville wants to defend himself and wants to continue with this trial, I think he is able to convince her not to remove him based on the transcript. All right, why is books? However, Woody asked about the statute for murder. Yes, I know. I get that. And the problem is Woody is presenting himself as a no-nonsense type of guy. So, books, the issue is he doesn't talk about... Okay, somebody remind me. Did anybody even mention the name Nut or refer to him at all in any fashion on the transcript? Did anybody say anything about Donovan Nut at all on the transcript? I don't believe his name was even mentioned. James Hasty, the transcript. Yes, the transcript might be redacted. But what is Judge Krauss, who we're looking at right now, what is she going to have in her hand? So y'all remember, I'm not so much talking about what happened in reality as I am, meaning as it relates to the conversation I don't know what happened. Nobody here knows. All we know is what the transcript says. We do know that the transcript does a certain, and again, y'all, I'm giving us all kinds of video plugs here, but I'm plugging our videos, okay? 5 possible redactions.
Hi,
this was a little difficult. This video is a little difficult because you really don't know. You just don't know. One thing, you know what, to me, this was the strongest, since everybody's talking about redactions, okay? We're talking about this. This was the strongest evidence for redaction to me. Listen to this. This was the strongest evidence for redaction.
3. Lieutenant Dean entered the chambers and said there was a security issue. Judge Glenville and Lieutenant Dean exited chambers at 10:45 a.m. Judge Glenville returned to chambers at 10:47 a.m. The very next line is Mrs. Hilton continuing to talk to Woody.
Okay. Y'all, let me finish this.
But when Glenville returns, he makes no mention of the nature of the security issue or why he had to step away.
Okay, so for me, the strongest evidence, this might be redacted. To me, the thing that seems most weird, most strange. Bumpus is going to live 6 p.m. Friday. Okay, thank you. I will certainly subscribe. Thank you for that, Jason. Y'all, to me, the strangest thing of this whole transcript is you have a guy pop in and say we have a security issue. That is recorded. Glenville steps out. That's recorded. But you never know when Glenville comes back in the room. Think about this. How possible is it that someone calls you out of the room for a security issue? You don't say, oh, excuse me, I'll be right back. You don't say, you just get up and go, okay, fine. When you come back, isn't everybody wondering what that security issue was? Like, hey, is everything okay? Like, there's literally no acknowledgement from anybody in the room as to, hey, is everything okay? Oh, excuse me, but everything's fine. Don't worry about it. Something seems like is left out, because you're not going to call a judge out of a room on a security issue and literally nobody says, oh man, I wonder what's going on. Nobody mentioned, there's no small talk about it. And when he comes back, he doesn't say, oh, excuse me, y'all, but everything's okay. Let's continue. He just pops back in, silently slides back in. Now, the question would be, if there was small talk, do you get to leave that out of the transcript? If somebody asks for a water or a coffee, if someone says, excuse me, I have to go to the bathroom, do you get to lose that out of the transcript? Do you get to leave that out of the transcript? So do y'all think that's a valid question? So, okay, I'm going to say it one more time, y'all. Listen to this, okay? I'm going to play it one more time.
Number 3. Lieutenant Dean entered the chambers and said there was a security issue. Judge Glenville and Lieutenant Dean exited chambers at 10:45 a.m. Judge Glenville returned to chambers at 10:47 a.m. The very next line is Mrs. Hilton continuing to talk to Woody. But when Glenville returns, he makes no mention of the nature of the security issue or why he had to step away.
Okay, okay. That's what a full transcript is, everything said, antisocial. I agree. A full transcript would be a cough. Oh, excuse me, I have a cold. Cough. Anybody have a cough drop? That would be a full transcript. It would be everything. So I'm going to say that if I had to bet $1,000, this is enough for me to say that something was said here that was not recorded, because I find it almost impossible that you're having a meeting in which security of a witness is a question. You come to the judge and say, hey, we have a security issue. He steps out of the room without saying, excuse me, without saying carry on, without saying I'll be right back, without saying, okay, pause here until I get back. He doesn't say anything. He steps out and then slides back in and just continues the conversation. He never says, okay, everything's okay. He doesn't say, oh, don't worry, that was nothing. He just slides back in and just keeps talking. So I think, to me, this would be the top, even though we put it at number 3, this would be the most convincing argument that I have had for myself, because I convinced myself of this. Certainly would like anybody else, if you have something you would like to point out, we can pull up the transcript. Was Woody in the room at this time? This was, let me see. Miss Hilton, I don't know, told you on Friday, I have no reason to want. Yeah, of course, because Miss Hilton's talking to Woody. Look what she said. I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL. So they have been talking to Woody for a minute when this happened. Okay. So Woody's in the room. Miss Hilton's talking to Woody. What's going on with Woody? Why are we in this meeting? Two things, as Glenville said. One, his lawyer said somebody wants to harm him. And 2, we need him to testify. Hey, knock, or whatever. Can you step outside, sir? We have a security thing. A security thing? Somebody get in? Somebody break in? What's going on? No, sir, just step outside. Okay, you step outside. Excuse me, y'all. I'll be right back. Would the judge step outside without saying, excuse me? Am I being too petty with this? Am I being too nitpicky when we talk about a transcript and maybe the excuse me is left off? Because wouldn't he say excuse me? Or carry on? Or let's see what this is about? Wouldn't he say something before he goes out the room? Or does he just get up and walk out? Okay, let's just say he just got up and walked out. Fine. You know, he was concerned. He was concerned. When he comes back in, he's just going to open the door, go sit down, and literally, y'all look, I find that very strange. And I find it so strange that to me, it's unbelievable. Okay? Clarence Kennedy, somebody found out about, no, there is no explanation as to what this security thing, we have a security issue. They are in a meeting with a witness who they have a security concern about, and someone, Lieutenant Dean, steps up and says we have a security issue, but Glenville literally nobody ever says anything about the security except Lieutenant Dean. Glenville doesn't say, is it serious? Glenville doesn't say, excuse me, everybody. Glenville doesn't say, oh my gosh. He just gets up and, he's a military man. Maybe he just, grabbed his gun and was like, let's go. But he didn't even say that. But when he gets back, wouldn't he at least say, oh, y'all, don't worry. Everything's okay. Clarence Kennedy, that's a security breach. We don't know what it was. But to me, it's very strange that they included that little snippet. We have a security issue. We need to stop for a minute. Stop for a second, please. I covered this up with the 3. I don't know. Okay, so maybe Glenville exited and they stopped. Did they stop? Lieutenant Dean said we need to stop. We don't even know if they stopped. Wealthy Wisdom, when Glenville left to go check about the security breach, Miss Weaver should let everyone in the meeting know they are off the that's it. Like, we literally don't know what happened right there. I'm gonna tell y'all, Glenville was like, nah, that's my bong. Perry. So right here, can we all agree? Can everybody on this live agree that right here something's wrong? Is there anybody? I've seen people talking about how the conversation jumps around. If you were to transcribe what I'm saying to y'all right now, I'm stopping, I'm starting, I'm skipping around. If there was another person, they would be interrupting me. If there was one central person who had to try to put it all together, it would come out weird as a written thing. Okay? It would come out weird as a written thing. So I'm not so concerned by the stopping and starting. That's how people talk. Okay? But is there, okay, give Black with me. I seen people mentioning this. I haven't mentioned it, but they literally said you might want to close your ears, Judge. Why would he? Okay. I've seen many people mention that before, that they said you might want to close your ears, Judge. My question is, why would he want to close his ears? I'm not so concerned again that she says that, because that could also just be kind of like a saying, even though, but I definitely do see, I see where you're coming from, because the question is, why would he want to close his ears? I mean, she's saying, hey, if you told us about a murder, we can't use that information against you unless we have, well, we can't use that against you. Did y'all notice how she was kind of, anybody here ever been in sales? Because this is how you do in sales sometimes. Not me, y'all. Okay? Other salespeople. Bad salespeople. Okay? Like, you'll say, yeah, I mean, this car is really good. I mean, it won't break down unless you run into a really large puddle. And it's like, unless I run into a really large puddle, quite possible that I will run into a really large puddle. No, but I mean, how likely is that? Very. I live in a rainy city. So when she said to Woody, Miss Hilton, she's like, well, we can't use your words against you and we can't prosecute you unless we have some independent evidence. It's like, okay, well, what if you have independent evidence? I mean, then this doesn't help me at all, does it? If you have that independent evidence, you know what I'm saying? This doesn't help me at all, does it? Or it helps me relatively little. You know what I mean? So she's telling Woody, if he confesses to a terrible crime, she can't use that confession against him, and she's trying to convince him that this immunity, to me, okay, y'all, this is me, again, this is my opinion. I can't read her mind. It looks like she's trying to convince Woody that she can't prosecute him, but she has to, as the lawyer, she has to keep giving the caveat unless we have independent evidence. So it seems like she's just trying to say that part. She's trying to emphasize no prosecution, Woody, unless there's some independent evidence. It's like, huh? What'd you say? Independent evidence. But I heard the no immunity part, but you said some more stuff. Yeah, immunity. Excuse me. I heard the immunity part, but what's the other stuff you said? Total immunity. We can't use anything you say against you, but we can prosecute you with independent evidence. Like, huh? What do you say? I'm sorry. You keep trailing off there. Yes, conditionally accepted. And they did mention federal immunity there. I don't know what that's about. I noticed that. They didn't. No, Earth Angel, they definitely did mention federal immunity. 100%. 100%. They mentioned federal immunity. Now, Earth Angel, you said they can't give him federal immunity. So did they secure that for him some kind of way? I don't know. So I can't say that he didn't have it. I don't know if he had it or not. But a state cannot give you federal immunity for sure. Did they work with somebody in the federal government to secure that for him? Who knows? I don't know. So I'm not going to comment on that. Okay, so back to the redaction thing. Because so we started this whole journey with what is Glenville's point of view? What is his perspective? Then we also went into what is he going to say when he gets in front of the judge? He's going to say to the judge, look at the conversation. You'll notice and listen to my explanation. We just called it to explain to Woody about his Fifth Amendment, about claiming the Fifth and his immunity and the consequences. That's what he's going to say. He's going to point to the transcript. He's going to have to point to the transcript. Then you all said, many of you said, hey, what about that transcript? It looks like that transcript might be redacted. And I said, well, let's take a look at the video that we did. To me, the most convincing part of the transcript, the most convincing piece of evidence that the transcript might be redacted is this right here. You have a Lieutenant Dean entering the chambers saying we have a security issue while you have a witness inside the chambers, specifically because supposedly there's an emergency about his security. And literally we have no conversation about that on the transcript. We only have Lieutenant Dean saying it, and that's it. So Julie Home, great video. Thank you. I appreciate it. I'm really just trying to express to y'all, because I've been thinking this through. And also I've seen, listen, y'all, there are a lot of great content creators out there about this. I've been watching a lot of videos. I think the lead attorney is one. AV to the seventh power, I think, is another one. Cat Knott Williams is another one. All these people are great, y'all. So, as far as their content, I've definitely been watching it. So some of these opinions and some of this analysis, I've definitely been able to glean from watching other people. So I'm giving people their props, okay? But not this though. This whole thing about the redactions is all me. Meaning other people might have spotted this, but I just literally sat down and thought about this myself. So there's other things I may have said that have come from other people, but not this part. So yes, I do think this is redacted. I 100% believe that this is at least slightly redacted. And then the next question, there's two more questions that follow up. One would be, Is it okay to just take out little stuff? Is it okay if Miss Bumpus' cell phone rings and it's her son and he's saying, Mommy, where are the Cheetos? And she says, boy, I told you the Cheetos are on the top shelf. Don't call me back no more. I'm in an important meeting. Does the transcript at least have to say Miss Bumpus answers a phone call from her son? Does it need to tell us? I'm not suggesting that happened, but I'm saying if it did, does it at least need to tell us Miss Bumpus answers a phone call from her son, or Miss Bumpus answers a personal call? Or can a complete transcript, unredacted, totally leave out that Miss Bumpus answered that call? Or does it have to at least tell us that she did? Again, I'm not saying she did, y'all. It's just a supposition. Okay, I'm just supposing. The Wealthy Wisdom, the transcript had to record every single thing once they're on record. So according to Wealthy Wisdom, if Miss Bumpus has that call with her son and she tells him where the Cheetos are, but the transcript should reflect that. If we are going by that standard, Wealthy Wisdom, if we're going to take that standard, there is almost no chance, in my non-expert but very well-informed by living in the real world opinion, there's almost no chance that this is a full transcript, because Glenville would have excused himself. Glenville would have said, excuse me. I'll be right back, y'all. Excuse me. I mean, wouldn't he? Am I tripping, y'all? I mean, he has manners, right? Happy Annie, a complete transcript needs to be complete. Would nobody in the whole thing have said, wow, I wonder what's going on? They just called him out for a security. Man, I wonder what that's all about. So in other words, y'all, this transcript is missing something, if for no other reason than right here. Okay. Let me just tell y'all a couple of other places. I found it weird. Let me just tell y'all a couple of other places. Might as well point this out. All right, 5. I found it weird. Y'all might not have found this weird. This might have just been me. Miss Bumpus, you can't switch how he gets called. Miss Love, see, that's not in Mr. Copeland's best interest. Y'all are hard on Miss Love, y'all. I don't know Miss Love. I don't have any partiality toward her, but she seemed to me like she was really trying to look out for Woody. Now I know y'all suspect her of whatever, so I could be wrong about that. But in this, what you telling me? Conditionally accepted. Miss Love is not looking out for Woody right here. See, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. Maybe Miss Love is just looking out for her prosecution. Maybe that's what it is. When you say switch in how he gets called, what does that have to do with anything? Bumpus, I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. Miss Love, that is not what he said in the email to you, and that's not what he relayed to the court. And his concerns have nothing to do with court. He was very much Miss Bumpus. I tried to go back and watch as much as I could. Y'all don't see like a real kind of weird, particularly with that last line. Miss Bumpus had not talked about watching anything. Miss Bumpus had not talked about watching, or am I wrong? I might have missed it. Y'all. Okay. But she said, I tried to go back and watch as much as I could. Nobody said watch what? I was like, what did she try to watch? Maybe she was talking about the video of the proceedings. Okay, think about this, y'all. Think about this. I'm about to break. Okay, I'm about to give y'all a hot take that I literally just had right now, right in front of everybody. And I got a hot take. Miss Bumpus said that she only came there so that she can get Woody to sign this paper saying that if he's going to testify, he's going to relieve his lawyer, Mr. Melnick, I think his name is, right? Think about this, y'all. Miss Bumpus's mind when she gets up in the morning is, let me go down to the courthouse and get this guy to sign this paper. Y'all ready? Miss Bumpus's, so she woke up in the morning. She got dressed. She put on all of her whatever jewelry and got her hair done, all that stuff. And she gets her piece of paper. And she like, let me go down to this courthouse and get this guy to sign this piece of paper as a favor, probably, to Mr. Melnick. Everybody with me? What did Miss Bumpus go back and watch as much as she could have? She wasn't preparing to be his lawyer because she said she was just going to get him to sign. Right, get black with me. He's only supposed to sign if he decides to testify. So Miss Bumpus goes down there. She's like, hey, if you're going to testify, can you sign this piece of paper for me? Miss Bumpus, she wasn't going down there to be his legal counsel, y'all. It's clear. She literally said, I'm not ready. I didn't even come down here for that. So what did she go back and watch as much as she could have? Was it the trial? She didn't. There was no conversation before this or after where Miss Bumpus said she watched something or she reviewed something or she studied something or she was brushing up on something. Find where Miss Bumpus talks about watching, reviewing, brushing up on, studying, getting informed about anything of that sort before or after where she says, I tried to go back and watch. It just comes out of the blue. It just comes out of the blue. So this was another place where I was like, watch as much as she could. Watch it. She watched day 87. Did she say that in the transcript? Why was she watching day 87 if she's just going down there to get him to sign a piece of paper? Not saying that she didn't watch it. She might have been interested. She might have wanted to feel prepared. Okay, that's fine. But she said, I tried to go back and watch as much as I could. So anyway, I found that it seemed like it came out of left field. I'm not saying anything against Miss Bumpus, y'all. I'm saying something about the transcript. Wealthy Wisdom. It is implied she doesn't have to. I lost it. Did you delete it? Okay. At any rate, again, I'm not saying anything about Miss Bumpus. I'm just saying something about the transcript. This comment seems to come out of nowhere. But y'all know what? Human brains are like that. Sometimes we just say some random stuff. So it could possibly be the case that she did say that at that point. I'm gonna check on one more, y'all. The last one. This is the whopper. This is the big one. But if you say something that you know, this is Miss Hilton. But if you say something that you know you did not do, like you admit to something you know you did not do, like murder don't have, like, oh, excuse me. Y'all didn't do my job. I was supposed to tell who's talking. Miss Hilton. But if you say something that you did not do, like if you admit to something you did not do, whether you, Mr. Copeland, like murder don't have like no statute of limitations, right? Miss Hilton. But if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Mr. Copeland. But y'all don't like Miss Bumpus. You can charge him with false statements and he will be back in here. That is what he's trying to say. Y'all, by the way, does it look like Miss Hilton is trying to convince him that he can tell a lie about something? Does it look like Miss Hilton is trying to tell him he could tell a lie, convince him he can tell a lie about something and he'll be cool? Anyway, where did Woody say I committed those crimes? Miss Hilton, he should, so long as he remains. This is him about going home this weekend. Miss Hilton, he should, so as long as he remains. But if you get up there and be like, if you get to testifying and then we get into it and you start saying I plead the fifth, we're going to be back in here again. Miss Bumpus. but if he says he don't recall to everything, he'll be okay. Ms. Hilton, I'm not advising that, but so long as he answers the questions, that's fine. So long as then Woody out of nowhere. I did these crimes. I'm telling you that. What crimes, y'all? What crimes is he talking about? If you read this transcript, they didn't talk about any specific crimes. Miss Hilton does refer to a previous conversation in which Woody apparently told her about some stuff he did in 2015. Go up, you're down too far. I'm down too far for what? I'm making a point, Stacy Lane. The point I'm making is, so Stacy, are you saying that, Stacy, do me a favor. If you could copy and paste, if you have this transcript in the chat, por favor, please. Sorry, y'all. My Spanish came out all of a sudden. Apologize for that. Stacy, if you could copy and paste where Woody talked about specific crimes. They didn't talk about any specific crimes. The only crimes that were alluded to were from 2015, in which Miss Hilton said you have. Miss Hilton says you have immunity. She didn't even say you have immunity. She said it's past the statute of limitations. So Woody was clear on that. But then he was like, what about murder? And then he says he did these crimes. Y'all, something's weird about the transcript. But at the end of the day, I don't think that's going to matter. I think, so I'm going to say this, y'all, and then I'm going to wrap up this first. Everybody here, thank you, by the way. This is my very first of this type of stream. Definitely plan to do more. So if y'all got some value out of this, again, like, subscribe, whatever you can do, definitely appreciate it. But I'm going to say this. This is my prediction. This transcript, Judge Krauss, who I showed y'all, she's not going to question. Yes, I did an AI audio of the transcript. Some people were criticizing that. Y'all, that took a lot of time. Let's listen to a little bit of that, y'all. I'm proud of this. I am proud of my AI audio, even though some people. This was my very first one. Nobody cared about Woody. That one was That was just one voice reading all the parts. It was okay. Alone, this is when we started using we started using a voice for each character. That was the first part. Y'all, I gotta play a little bit of this.
You know what's in your cheap protein powder?
I gotta play a little bit of this. Y'all, because the Woody voice, this is definitely Jesse Pinkman from the Wire, from Breaking Bad. Okay, this is definitely Jesse Pinkman. I tried to do it myself, but it was too hard. Yeah, this took a lot of work.
And I said that you don't know what I did.
This is Woody,
what I
bro.
ain't do.
This is
and then
Woody.
you was like something. And then y'all asked for this immunity, and I was like, it was something. And then Thursday or Friday came, and then y'all go tell me, oh, we went to the judge with this, so you gotta testify. If you don't testify, the judge gonna lock you up.
Right, but that was based upon what you...
But I told y'all that.
No, you didn't.
You said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened.
And I said, I don't know what happened. Only you know and them know, I said. But you never said, I am pleading the fifth. You said, what if I do this? What if I do this? What if I do this?
I told you, I said I'm going to plead the... You said, why would you plead the fifth to something that you know you didn't do?
So if you didn't have immunity prior to, is that what you were saying?
That's
That you
Bumpus.
feel like he
That's
didn't have
Bumpus.
immunity prior to?
Immunity came Friday, right when I went to jail.
The immunity only came after Mr. Melnick.
Hold on.
Bumpus.
The immunity came after Mr. Melnick sent us an email saying, my client is pleading the fifth. That was on Thursday evening at 6.
Okay.
So after that was an emphatic, he is pleading the fifth.
Uh-huh.
We came and we got this signed.
Uh-huh.
And then Friday...
All right, y'all. So that's AI. Yes, generating each person's dialogue, putting it all together. Yes, quite a bit of work. But at any rate, the final thing that I wanted to say to y'all is this. I think, oh man, if I'm wrong, it's gonna be on wax, y'all. I think Glenville survives the recusal, hearing, and I'm gonna tell you why. I'm gonna give you all my reasons real quick. I don't know why I'm saying real quick. I'm really not in a rush, but trying to respect y'all's time. These are the reasons why I think Glenville survives the recusal hearing. Very most basic reason: he's being judged by another judge on his court. Yes, somebody mentioned earlier that he's the chief judge, and so these are his inferiors. Yeah, my understanding is that chief judge is like a rotating title, so that different people will have it for like a year or whatever the case may be, for a certain amount of time. So it's not like he's chief judge as in any kind of permanent or way due to merit. It's based on maybe some kind of random rotation or something like that. With that said, he is the chief judge. So the fact that, everybody gets to be the chief or something, well, everybody else is not the chief right now. He's the chief. So while he's the chief, he is the chief. So we can't say that there is, even if it's just a title, even if you're just the person who gets the keys to the break room, it doesn't matter. You're the chief. You have the title. So in some sense, everybody else is your inferior, even if it's just they don't get the keys to the break room and you do. I don't know what it's about, but that doesn't matter. He's the chief. That's one. He's on the same court as the person who's judging him. That's two. They are judges. That really should be number one. They're judges. They're all going to look at this and say, this is a very difficult job, and this is one of the biggest cases ever. And if this were me in that position, or if this were I in that position, how would I handle it? And would I make all the exactly right rulings? And would I want somebody scrutinizing me for every little thing? And would I want somebody trying to kick me off of the bench for this? Conditionally accepted. I think your info is outdated. Be more specific, please. What info is outdated? So, be more specific. What's not the same? Or are you talking to somebody else? I don't know what you're talking about. So I think they're judges. I think they're gonna say, man, I wouldn't want some. I mean, look, I'm having this ex parte meeting. I might feel like I need to. I kick him off the. Okay, so they're judges. They're subordinate to him in some sense. He's the chief. They work with him. Okay, conditionally accepted says not for. I think if you move it to another county, even still, it still favors Glenville. If it stays in, I'm saying I think he survives, particularly if it stays in Fulton County. Okay, if it gets moved, I still think he's going to be 60-40 to stay. In Fulton County, I think he's over 60. He might be 70-30, 75-25 to stay. Okay, if they move it out of Fulton, I still think he's 60-40. At this point, anything could change. But if it goes in the way it is now, I think he's still 60-40. He's a judge. He's a chief judge. He's being judged by a colleague in Fulton County on the same court. That colleague has been in numerous hearings. They've had to make split-second decisions. And they're going to say, would I want somebody challenging me and trying to kick me off a case for this reason? He has given his three-pronged defense, which I think, honestly, if you're looking for a reason, if you're more favorable to keeping him, which we have to imagine his colleague would probably be, this three-pronged defense gives you enough cover to say what they said in Adams. The appearance of impropriety. It looks bad. They have to say that. But at the end of the day, whether the defense was there or not, from his perspective, going into this meeting, just trying to tell Woody about this Fifth Amendment thing, the defense didn't need to be there. Now, what did eventually happen in the meeting, maybe the defense needs to know about, but hey, there's a transcript. I'm looking at it right now. The whole world has it, and defense has it before they have to cross-examine Woody. So I'm not saying I think that's dirty, as Jay Smith says. I'm not saying I think it's dirty. I'm not saying I think it's wrong. I'm not saying I think it's right. I'm not saying it's up, it's down. I'm simply analyzing from my perspective. I think, okay, so DMV notary team says that it might be appealed, basically. Yeah, it might be appealed. And at the next level, who knows? I'm talking about this first round. I think Glenville goes in there. He has the sympathy because he's talking to his colleague, because he's talking to his temporary inferior, because he's talking to somebody who is a judge who's been there, done that. It's like a baseball umpire, y'all, or a basketball ref or a football ref. Somebody who's been doing this for 20 years. Now you're calling somebody in for a controversial call. They're going to be like, I made 1,000 controversial calls. I don't want people trying to kick me out of my job because of a controversial call. You know what I'm saying? So, and then you allow them to make their case and they start bringing up other controversial calls where higher court said they were okay. Okay, well, hey, doesn't look good, but the appearance of impropriety, but he had a reason to believe that the defense being there, again, from the perspective before they start the meeting, he had a reason to believe the defense didn't need to be there. And once he saw something happen during the meeting, he gave them the transcript before it was time for them to cross. The biggest thing working against Glenville, the only thing I think that can sink him at this point is the way he reacted in court. I'm not a judge, y'all. Again, law school grad, yes. Lawyer, no. So I am not speaking based on anything but just gut feeling. I think that Glenville's reaction, where he did not acknowledge the defense's right to know about that meeting and about what happened. I think that could be, if he gets sunk, I think that's going to be what does it, or that will be a contributing factor. He might get sunk because he seemed to react like you shouldn't even know about that. And the whole idea of having it transcripted is so I can tell you. But then he's just going to say, yeah, they need to know, but I need to be the one to tell them, and I didn't have time. I don't want people leaking out of my Are we still live? Are we still live, y'all? Okay. I got a message saying that OBS disconnected. I don't know if we're still live. So y'all, I guess we're still live. So that's gonna be it. That's gonna be it for me, y'all. I'm giving Glenville. Okay, Courtney, thank you. I'm giving Glenville. Courtney, is that Courtney one of our students? If that's Courtney, one of our students, let me know. So I'm giving Glenville 75-25. At this point that he stays. So just break all of your rules. Y'all, listen, I'm not defending Glenville. I'm telling you, hey, Courtney. Oh, cool. Got one of our students in the house. Appreciate the support, Courtney. I'm giving Glenville 75-25 that he stays. I'm not saying I want that to happen. I'm not saying it's my preference. I'm just telling you the way I see it. Telling you the way I see it. So, y'all, I want to thank you. This is our first stream. We even got a student that came through. Appreciate that, Courtney. That's really good. Check out all of our videos. Thank you all for the support. We're going to be doing this a lot more often. I really do love talking about this sort of thing. Yeah, y'all. So all of you are our first live people. So when we blow up, y'all can say, yeah, I was there from the beginning. So I appreciate y'all. Okay. Y'all take it easy. Have a happy 4th of July, and we'll be back